direction here. Good morning. It is 10 a.m. on Friday, May 3rd. Welcome to the Public Safety and Justice Committee meeting. I am calling to order and looking to the clerk for a roll call, please.
Vice Chairperson Chavez
Here.
and Chairperson Ellenberg.
I'm here as well.
Thank you. We have a quorum.
Thank you very much. And do we want to put the agenda up on the big screen? In the meantime, I will open public comment. This is the portion of the agenda set aside for members of the public wishing to address this committee on members not on today's agenda, but within the purview of the Public Safety and Justice Committee. Do we have speakers this morning? Nancy, sorry, I'm asking you to do 10 things at once.
We have 2 speakers on Zoom and no speakers in chambers.
No speakers in chambers? Okay, let me just wait a second or two. If anyone else desires to speak on Zoom, now's the time to raise your virtual hand. The queue will close when the first speaker begins speaking. We holding
And we
it two?
still have the 2.
Still 2. Okay, 3 minutes, please, for each speaker.
First speaker is Ben. Ben, I'm unmuting you. Please accept the unmute. You have 2 minutes to speak.
Yes, hello, good morning. I've been addressing this committee for more than a year now, telling you guys that my kids are being sexually abused. I've told you that my son has confirmed that beginning when he was 13 years old, he was being raped. And nobody here on this committee is doing anything to help me. I mean, this is completely absurd that you guys have pledged to protect the community, and you guys are just ignoring me. It should be making you sick to your stomach when I tell you that my youngest was just 2 years old when this was happening. But it doesn't. In Supervisor Simitian's words, it's mind-boggling that you guys are letting this happen. And I mean, we have people from the district attorney's office here present, county council, the county executive, the sheriff's office. I mean, you guys have all been hearing me for more than a year. And I reported this in 2015. I reported it to CPS. In 2017, I started reporting it to more people, to the board of supervisors. And here we are in 2024, and you guys just ignore it. I mean, it's really disheartening that you guys do this to kids. I mean, this is you guys doing it, because if you guys wanted to, right this second, I'd be able to get a screening for my kids, and then they'd be protected. But you guys are refusing to do it. And it's really terrible what you guys are doing. You guys are doing it. I mean, this is sexual abuse by proxy. If you guys wanted to stop it, it would stop, and you guys aren't stopping it. So I want to plead with you guys again. I mean, all the people who can help are right here present at this meeting. Please help me get a screening for my kids, please. Supervisor Chavez has all my contact information if you guys need it. Many of you guys have already received emails directly from me. Please, thank you very much.
Next speaker is Shabana. I am unmuting you. Please accept the unmute. You have 3 minutes to speak.
Good morning, everyone. Thank you for having me come and present a little bit. My name is Shabana Ansari. I'm a legal advocacy coordinator at Maitri. Maitri is one of the pioneering organizations in the nation to provide culturally responsive services to South Asian individuals experiencing domestic violence. Since 1991, we have been providing multiple helpline, multilingual helpline, legal advocacy transitional housing and other supportive services. The reason I'm here and making this comment highlighting the importance of the helpline as is the first entry point for people seeking help, and the huge cut for VOCA funding, how it will deeply affect all the organized domestic violence organizations who are working very closely with the district attorney's office, with the victim services and family justice center, and how it has been helping. The helpline, the highlight of the helpline for us is the first entry point for people who are seeking help. We have trained advocates who are fluent in multiple South Asian languages. At Maitri, we firmly believe and make sure that language needs are addressed. And this is important aspect for a survivor towards empowerment and understanding their rights and options. Maitri's live helpline is from 9 a.m. to 3 p.m. We have 2 trained advocates who provide culturally responsive and crisis intervention, safety planning, and address their immediate needs, and peer counseling and reference. In fiscal year 2022 and 23, we received 1,764 calls, out of which 566 were crisis calls. These are the just number from one agency. You can see that there are other 4 agencies who are in Santa Clara County providing the similar services. And the importance of the helpline and this funding is that I can share that 93% of our clients that we surveyed and how they have reacted to the testimony from a survivor is, I'm gonna share that I'm so thankful that you not only spoke to me in my native language, but made sure you understood without any judgment. And now I'm feeling confident that I can manage and get out of the situation. I really, truly urge everyone here to support that the more than 45% of VOCA funding cuts is actually gonna deeply impact the organization and the work that we do towards helping domestic violence and sexual assault survivor. And it's really gonna be a huge burden for an organization to continue to do the service, provide the services. Thank you.
That concludes public comment.
Thank you very much. We'll move on to item 3, which is approval of the consent calendar. My office received a request to hold item 8 to the next Public Safety and Justice meeting, so that item will be heard at our June 27th meeting. Item 11, I'm glad to keep on consent. Just want to make a quick comment. I was really pleased to read about the launch of the program and want to direct staff to report back to this committee at our November meeting with a progress report. Item 11 is the report from the Office of the Sheriff relating to implementation of the Clean Slate Residential and Commercial Janitorial Skills and Safety Program. That really is exciting new work. Do you have any, and that would be my motion.
I'll second that. I know what I am.
Oh, you're on now. It's on now.
Oh, I think I unplugged the mic, trying to plug in my phone. So, yes, I'll be happy to second that motion, and I have 2 requests. One, I'm really excited about the Clean Slate program. There is a matching program that also does job connection that I'll send Sheriff Johnson you so that you can make that connection. I think this is really exciting, and I'd be interested in if the curriculums are similar, so that's really exciting. And then on item 12, the cuts to federal funding for victims, this is actually a pretty devastating cut, especially as it relates to VOCA. And one recommendation, District Attorney Rosen, I know you all are doing a lot around communication. I would just like to ask that we invite the board to participate in any both communications and rallies, and our nonprofit partners are very concerned about these cuts, particularly as it could impact the Child Advocacy Center as well. So if you wouldn't mind informing us and our partners so that we can also play an active role in protecting those resources.
Yes, of course, and we have
Great.
people to present on it later when we get to it.
Thank you.
Thank you. We have a motion and a second. Do we have public speakers on the consent calendar?
There's one speaker on Zoom.
All right. Noting to speakers on Zoom, your hand needs to be raised before the first person begins speaking in order to be part of the speaking queue. So we'll hold for a second. Do we have any additional speakers?
There's one speaker.
Holding at one. All right, 2 minutes, please.
Ben, I'm unmuting you. Please accept the unmute. You have 2 minutes.
Yes, I mean, we really have to take it seriously when we're going to get cuts to victim services, because, I mean, we really need to protect victims of crimes, and so we need to think of ways, just in case it does get cut, that we can keep those services going, all the services that we need for victims. And I have a proposal, two things that we can make up the shortfall if it does happen. Number one, there's Daniel Chung. He's sitting at home. We're paying him to sit at home. And all he wanted to do was protect my kids. And I mean, that's hundreds of thousands of dollars that we could be putting back into the district attorney's office to help protect people. Number two, stop prosecuting victims. I mean, like, I told the district attorney's office that I was being assaulted and that my kids were being sexually abused, and I got charges against me in an attempt to discredit me. And that's just wrong. I mean, think about all the time and the resources and the money that we're dumping into these, when we could be protecting people, and also at the same time, we could be reducing the number of victims we have by holding people who commit crimes accountable. And we're just not doing that 100% of the time. I mean, like, who knows how many victims out there are being prosecuted and who are also continued to be victimized because people just in power, they just don't care about what's going on. And so, I mean, if we could make these two changes, I mean, we could totally make up for this shortfall or potential shortfall. Thank you very much.
That concludes public comment.
Thank you very much. Let's vote to approve the consent calendar, please.
Vice Chairperson Chavez? Yes. And Chairperson Ellenberg?
Yes.
Thank you. Motion carries.
Thank you so much. As we begin our regular agenda, I'll note that we need to conclude at 11:30 today due to a loss of quorum. So I will ask everyone to be your, of course, usual efficient and impactful selves, please. Item 4 is a Community Corrections and Law Enforcement Monitoring Committee fiscal year 2024 work plan, and Walter Wilson, who is the chair of CCLEM, is going to present on that item. Is Walter with us on Zoom or in person?
I see a hand raised on Zoom. I am going to unmute the individual. They don't seem to have added their name to
Let's see if
Zoom.
that's,
So we'll see if we can
that's him.
identify him.
Yes, it is Walter Wilson. Good morning, everyone.
There you go. Go right ahead, please.
Good morning, Chair and Vice Chair and Committee. Thank you for allowing me the opportunity to make this verbal report for you regarding the CCLEM, excuse me, 2024-25 work plan and 2023-24 accomplishments. I'm going to start with our mission statement, if that's okay with you, Chair. The Community Law Enforcement Monitoring Committee was established to improve public transparency, accountability, and engagement with respect to issues of public safety broadly defined, including but not limited to policies and practices of the Office of the Sheriff and the Department of Corrections. The committee shall serve as a focal point for community engagement with efforts to reimagine the county's role as a public safety service provider through a racial and social justice lens designed to encompass law enforcement, crisis response, behavioral health services, diversion and prevention, and other health and social services that strengthen communities and make them safer. The committee shall provide a forum for consideration of cross-sector, equity-promoting public safety recommendations bringing together members of the community with county departments and drawing on expertise developed by the community organizations, and other county boards and commissions. The committee shall provide opportunities for community engagement and advice/recommendations to the Board of Supervisors, the Sheriff Office, Department of Corrections, the Office of Correction and Law Enforcement Monitoring, and other relevant county departments. The historical background: the committee was established by ordinance number NS 300.923 on April 3rd, 2018, and its mandate and responsibilities were expanded by ordinance number NS 300.945 on October 6, 2020. Bylaws were adopted by the committee's first meeting on March 5th, 2021. The committee serves in an advisory body to the Office of Law Enforcement Monitoring, Oakland, the Board of Supervisors, and through the Board of Supervisors to the public, with responsibilities and authority enumerated in Ordinance Code A6-283. The committee consists of 9 voting members, 1 member nominated by each supervisors, 4 members nominated by the Office of Correction and Law Enforcement Monitoring, all subject to appointment by the Board of Supervisors. I'm going to go into our work plan, and starting off with number 1. Our goal and objective to review current practices and make recommendations to strengthen communities and make them safer. And the proposed activities are to receive updates on the consent decrees and jail reform efforts and how they strengthen communities and make them safer. Review in custody health and rehabilitative programming options and provide recommendations to strengthen communities and make them safer. Assess top community safety issues not associated with law enforcement interaction or incarceration. And we give this a priority ranking of 1 as our priority. And the completion date for this is July 2025. Number 2, under goals and objectives, develop a community engagement strategy to solicit input relating to county criminal justice initiatives that improve community safety, promote treatment and rehabilitation, and decrease recidivism. Our proposed activities are to learn more about the criminal justice system in Santa Clara County and organizations serving justice-involved clients by inviting the Police Chiefs Association, District Attorney, Public Defender, Probation Chief, and community-based organizations to present strategies that improve community safety, promote treatment of rehabilitation, and decrease recidivism. Encourage community engagement and input on topics that impact community safety. And we gave this a priority ranking of 2, and the completion date will be May 2025. Number 3, under goals and objectives, is to receive updates and make recommendations regarding the county's custodial facility replacement project, AKA the new jail facility. Report on the best practices for custodial facility design and function from the ad hoc subcommittee. Continue receiving updates from administration relating to custodial facility replacement project. We have a deadline, a priority ranking of 3 on them, a deadline of November 2024. Assist Oakland in developing recommendations related to the Sheriff's Office policies and practices, including jail operations through a racial and social justice lens. Excuse me, the activities to accomplish that is to develop recommendations relating to the Sheriff's Office personnel policies and practices, receive reports on the Sheriff's Office use of military equipment and use of force, develop recommendations relating to inmate advisory councils, grievance processes and inmate services such as phone calls, tablets, commissary, and the digital inmate tracking system, with a priority ranking of 4 and the deadline of July 2025. Prior year accomplishments, goals and objectives. Number 1, Oakland is developing recommendations related to the sheriff's office personnel policies and practices. Activities supporting that goal will receive a preliminary presentation from Oakland, from the Office of the Sheriff in September 2023. Receive information relating to information sharing agreement Oakland executed with the Office of the Sheriff. Milestone, excuse me. Number 2, review and make recommendations regarding actions to improve jail operations. We received reports relating to inmate advisory councils, which is ongoing. Discuss the clear out referral with Oakland, which is also ongoing. Number 3, provide recommendations to support strategic county initiatives with the goal of improving community safety through quality care for justice-involved individuals and their families by improving services provided in custody and upon re-entry that promote rehabilitation and decrease recidivism. These activities are to receive presentations from the Office of the District Attorney, CAMP unit, the Pretrial Services Department, the Behavioral Health Services Department relating to services provided to the community for justice-involved individuals. Received information on the jail population from the Office of the County Executive and the Office of the County Council, and that's also ongoing. Number 4, receive updates and make recommendations regarding the county's custodial facility replacement project. Received informational updates from the Office of the County Exec, formed a custodial facility design and function ad hoc subcommittee, also ongoing. Number 5, deepen Sequim's knowledge and understanding of law enforcement aspects of the Sheriff's Office. Solicited community input on the Sheriff's Office procuring tasers. Received information on the Sheriff's Office use of unmanned aerial systems, military equipment, and use of force, also ongoing. And that concludes my report.
Thank you so much. Somebody else. Thank you so much, Walter, and really much appreciation to the entire CCLEM committee for your commitment to improving our justice system. I look forward to the work over the year ahead. I will look first to see if there are any comments from folks on the dais, and if not, are there public speakers on this item?
There are no requests to speak.
Okay, would you like to make a motion to receive the report?
Yes, I will move approval.
And second, and still seeing no comments from folks on the dais, let's vote, please.
Vice Chairperson Chavez
Yes.
and Chairperson Ellenberg.
Yes.
Thank you. Motion carries.
Thank you so much. Item 5 is a report from the Public Defender and District Attorney relating to the implementation of post-conviction sentencing reform legislation. And welcome Damon Silver, who is here today representing Molly O'Neill, Public Defender.
Thank you. I'm going to hand it off to our staff. Deidre Edgar is the supervisor of our post-conviction team. I'll let Deidre and Netta introduce themselves.
Good morning. Is my speaker working?
It is.
We're going to put a PowerPoint up to follow along with during our presentation. Good morning, everybody. Thank you for this opportunity to allow me to share how Santa Clara County staff employees are addressing and responding to the legal mandates that the state has imposed to our counties to reform the criminal legal system. Santa Clara County has 3,000 people in state prison, and we are fortunate to have these reforms that have, the goal is to seek equity and fairness and redeploy incarceration costs into more positive outcomes. The reform movement began around 2011 with AB 1109, which I'm sure this committee is familiar with, when we had a response to prison overcrowding. Since 2011, when we looked at realignment and we started making efforts locally to help our clients and help our citizens rehabilitate, the prison population has still grown, and the state of California, both the voters and the legislature, implemented more reforms, particularly in 2018. Currently, we are responding to our responsibilities to the citizens of Santa Clara County in implementing and realizing these reforms. And we didn't necessarily receive sufficient or any additional resources to do that. But I am proud to report that we are having successful outcomes locally and certainly statewide. So let's talk about these reforms. On the screen, you'll see a list of reforms, and we wanted to present this in a way that makes sense. On the left are the goals of the reforms, and to the right are the penal code statutes that aim to achieve equity, fairness, and cost savings, as well as years of life savings to these populations. So we are currently in Santa Clara County, and in particular the Public Defender's Office, we are responding to 10 different legal statutes listed on the right with the goals of seeking equity and justice and fairness to the populations of our community on the left. We have youthful offender parole. These are people that are incarcerated and that were so incarcerated before the age of 26. We now in the criminal legal system have accepted the neuroscience of our academic researchers, and that the human brain does not stop growing until the age of 25. The last part is the executive functioning of the frontal lobe. And we know, just anecdotally, that when we're young, we do crazy things. We don't do risk and benefit analysis, and in part, we're not biologically fully developed. So the state of California has instituted Penal Code Section 3051 that provides us an opportunity to assist those younger people that have been incarcerated for decades, some of them now in their 50s, 60s, and 70s, to achieve a youthful parole hearing, to come to the parole board a little earlier than those people that were more grown up at the time of their crime, and prove that they are rehabilitated, they are not disposable, and they have great value to bring back to our community. In the same vein, Penal Code Section 1170D, which is, we call it juvenile LWOP, people that were under the age of 18, children that were given life sentences without parole. Now the state of California and the state of the law does not find that fair and just. So we are able to review those cases under this penal code statute and bring these cases back to court and ask for sentence reviews. That is the function of all of these. All the 10 statutes give us an opportunity to bring clients' cases back to Santa Clara Superior Court and review them for equity, fairness, and prove that people can and do rehabilitate and bring something of value back to the community. The Racial Justice Act, Penal Code Section 745, just came on alignment January of this year for people in prison. That means that the 3,000 people in state prison, we have an obligation to review their cases, and if there was any racial animus or bias involved in their prosecution, they have a right to make a claim retroactively. That is a huge lift, and we both, the Public Defender's Office and, if I may, the District Attorney's Office, have a huge amount of work to do to respond properly to this population. The next two, where we look at reducing jail population by exceptional conduct, the Penal Code provides that the wardens of the prisons can send cases back to Santa Clara to say these people that are incarcerated have done exceptionally well. And the warden then gets to refer them back, and the court now must review these cases. We've had such cases. One of my clients had served 18 years in prison, got an exceptional conduct referral back to the Santa Clara County Court. He's a paralegal. He was married for 30 years, has 4 children, and didn't have any rule violations in 18 years. He was convicted of robbery, and through litigation in the court, the judge granted the exceptional conduct, and he was released under that statute. The court now, as of January 1st, also has a court recall power, and they can bring cases back on their own. And the District Attorney's Office has the same power, and I am proud to share that our office collaborates very closely with the District Attorney's Office. We have been able to release people by cooperation and collaboration. back to the community through working with the district attorney's office and providing our reentry support and creativity to ensure public safety in those cases. We have military veterans recall, where people that served our country and were injured, but who happen to be serving a time in prison, also can have their cases released back to the courts for review, and people that are dying in prison have an opportunity to do so in the community. All of these things are the 10 legal reforms that we're working on, and we do continue to provide expungement relief for those that have completed their sentences. So far of last year, we served 2,400 people with expungements, and in the last 10 years, we've consulted with 22,000 people in Santa Clara County to help them get record clearance reform. Reforms have achieved success. There is successful outcomes to report, and I'd like to share just 2 examples with you now. The first slide is a cost savings example that I refer to as A. This is a slide of cases that were resentenced here in our county, either in collaboration with the district attorney's office or at the request of the wardens of the prisons of the state of California. In 1 year, we were able to achieve resentencing for 21 men, and the highest percentage were all men of color. These revised sentences saved these men 396 years of incarceration, and by estimates, upwards of $42 million to the state of California, depending on which cost estimate we use per person per year. This is just one subset of the 10 reforms that we've been working with in Santa Clara County, and this is one that shows great collaboration and efforts. When we work together to achieve fairness and equity, people get to return to the community, and we are all better for it. The next slide is going to show an example statewide. That means that statewide, California resentencing under this subset, this one legal reform is warden prison referrals. For 1 year, for 4 years, the wardens of the California prisons referred 1,260 people back to their county courts. Of those 1,260 people, 414 received reduced sentences, which saved the state of California over 2,000 years of incarceration and the people. That resulted in about $232 million. This is just one subset of 1 year of savings when we take incarceration and we do something different with those dollars, those years, and our time. Probably the best way I can illustrate how this works and how well we've done, I'd like to introduce you to Mr. Jerome Fosselman. He's sitting behind me, and he has put in a speaker's request. Mr. Fosselman was released in July of 2023 by agreement with the district attorney, Deputy District Attorney Ted Kajani, and Public Defender Anjali Bhargava. The two of them worked diligently to reach a fairness equity new sentence that the court approved in June, which resulted in Mr. Fosselman's release. He is now 67 years old. He served 20 years in prison for a crime of robbery of $50.23 of merchandise at the Marina store on Monterey Road. After 20 years of incarceration, this review of his case resulted in his immediate release. He has now had been living in transitional housing that our community support person arranged. He enrolled in De Anza Community College, where he's a student now. He'll be transferring to San Jose State. He is seeking to be a paralegal, and he started that endeavor while in prison. While it is new transitional housing, there were 6 other men that were formerly incarcerated who often would complain about boredom and nothing to do and difficulties of reunification. Mr. Fosselman spoke to them in a way in which an elder could and said, you should get off your chair and get to school. If I can do it, you can do it. And he has now enrolled 9 formerly incarcerated individuals in De Anza Community College under the RISE Act, which is one of the resources our community service outreach specialist, Anna, who is behind me, has arranged for him. Not only did he enroll in school and enroll these other gentlemen in school. He holds court on the campus daily to ensure they're attending class, they're studying, and they're doing something with their time. Mr. Fosselman recently bought a car, which is depicted in this, and he also has 2 jobs. Full-time job at a rental car company, and as of 30 days ago, he received his first own studio apartment through the assistance of our housing services in the county and by the guided hand of Anna Jimenez, our community outreach specialist. This is one example of many that shows that our intentional functional reentry services and work, where we pull already existing resources together to assist and guide people re-entering into our community. And by doing so, it ends the cycle of recidivism. Mr. Fosselman has not been rearrested. It ends the cycle of fear in the public about what people are like when they come back. And at the bottom line, it ensures public safety. He's paying taxes, and he's mentoring others, and he's not even charging any of us for those services. I think the last slide I should comment on is the impact on our office. It is definitely a busy time in the Public Defender's Post-Conviction Unit. We are serving a population in prison that is quite large for our size county, and our resources have not grown. Our inmate population as of last March was over 3,000 people in state prison. We currently have over 300 open cases for review in these fields of these 10 legal reforms, and we've already had almost 800 new expungement contacts just in the first quarter of this year. Our most pressing issues, both for the public defender and for our partners in the courts and the district attorney's office, is we have newly enacted legislation as of this year, both the Racial Justice Act and court recalls, which means that the court can recall these cases on their own authority, and you can bet that our community advocates, people in prison, and other advocates are asking us to please bring all these cases back. I get calls daily saying, what are you waiting for? The law passed 4 months ago, and we're doing the best that we can to respond to our responsibilities. This is not the end of the game, this is just the beginning, because there are more new laws coming online in about 9 more months, or in January of 2025, which opens up these reforms to virtually everybody that's had a prior conviction. We are just getting started, and we are barely holding on. Some of the things that we were challenged to do, my bosses asked me, how are you going to handle the workload with no new resources? Give me a plan today of what you will do. And so this has been our plan in the Public Defender's Office. We've increased our community outreach to absorb the resources of our Veteran Services Office, the Social Security Service, Medi-Cal, other types of nonprofit providers such as the Recovery Cafe on 5th Street, and our outreach attorneys have gone out to pull in resources that already exist so we can wrap those around people like Mr. Fosselman, and you will also hear from Mr. Campbell, who's behind me, who has served 44 years and was released from prison a few months ago. These resources of wrapping around existing resources have not cost additional money and has saved lives and have allowed us to provide the necessary reentry services to fill the gaps that we all know cause people to end up back in prison and not ensure public safety. We've also started for the first time a post-conviction student intern program. Right now we have 10 interns that are working for free every day of the week from our local Stanford and Santa Clara Law Universities. Undergrads and law students come in every day to review cases, work with us, and frankly provide expertise from their life experience and from their studies. We are very grateful to have this huge free labor population, and that is an ongoing effort. Community partnerships I've already spoken about, and we have spent our time, in addition to doing legal work and reentry work and student recruitment, we've also done grant outreach and submitted and achieved grants from the Office of the State Public Defender to help us do Racial Justice Act claims. The grant is not large, it goes over 2 years, and it only funds a 25% attorney for those 2 years. which is a drop in the bucket, but it is ongoing efforts to look for money outside of the county and to pull in what we can with exactly no additional resources, which was our mandate. I think at this point, I'm very grateful to have this opportunity. I welcome you to listen to Mr. Fosselman and Mr. Campbell when they have this moment, and I would pass off to my colleagues at the District Attorney's Office if they have anything further.
Are there further comments on the presentation? If not, we'll go to members of the public. We'll begin with the two gentlemen that you indicated submitted cards. If there's anyone else, glad to hear them, and then we'll return to the dais for conversation.
We have the two requests to speak from the gentlemen that were mentioned earlier, and there are no speakers on Zoom.
Okay, perfect. Then each speaker has 2 minutes, and there's a clock up here that will begin counting the time when you begin speaking. So take your time to get organized there.
Okay. Good morning. I would like to read from our previously
And
prepared.
sorry for 1 second. We'll stop the clock. Can you increase his volume, please? Try again. We'll make sure we can
Good
all hear
morning.
you.
I would like to read a statement that I prepared earlier. I'm here to speak in support of the Santa Clara County Public Defender's Office. I was released from state prison on July 5th of 2023 after serving nearly 2 decades. Prior to my last prison term, I served approximately 15 years in the California prison system. However, my last release from prison is different from my previous prison releases. The reason for my success in reentering society has been the assistance I have received from the Public Defender's Office. From day one, the Public Defender has assisted me to the point that I am convinced if I had received the assistance that I am now receiving from the Public Defender's Office, I would not have reoffended after being released from my 5 prior prison commitments. The Public Defender's Office started assisting me before I was released. For example, my attorney and the social workers from the Public Defender's Office secured housing and group therapy for me prior to my release. In addition, 2 social workers from the Public Defender's Office were at the prison gates on the morning of my release to make sure that I made it to the sober living home, which was secured for me by their office prior to my release. I was provided with clothing, assisted with getting a cell phone, taken to the motor vehicles office to obtain my California ID card, taken to the social services office.
Sir, I'm so sorry. I hope the public defender had let you know about the time, but I want to make sure that we have the whole statement. So I wonder if you could work with the public defender's office to send a copy of the full statement so that we can put it in the record and everyone can hear every word that you had to say, please.
Okay,
Thank you so much, and we'll call the next speaker.
thank you.
Thank you, sir. Welcome.
Good morning. We're going to make this short and sweet. I did 44 years for the crimes that I committed. And if I would have had the help that I have right now, without the public defenders, I was scared as hell coming out of prison after doing 4 decades. And with their assistance, they made it easy for me. They made it where I can transition, where I can come out and be safe and know that the public is safe to know that someone like me come out and willing to do the right things. You don't know the help that y'all give to people unless you actually do it. And without them, I don't know where I would be. They made me where I'm successful, where I got things that I have never had, and I'm stable. That's the help that they give. And it'd be a shame if they lost that. Because people in prison really need to know that somebody out here care. And if it wasn't for Anna and Deidre, I don't know where I would be. So the blessing is to them, and the blessing would be to y'all to keep them. Thank you.
Thank you so much. Thank you to both of the speakers and the presenters. The significant cost savings that you noted, an estimated 15 to 106,000 per person per year, is compelling enough on its own to dedicate significant resources to this program, but the immeasurable positive impact on an individual's life as they regain freedom, re-enter their communities, our communities, is really almost, you know, as the credit card companies say, invaluable, and can't put a price on that. So I think it was a powerful presentation and important for all of us to hear, and certainly going into budget as we think about the elements that truly increase sustained public safety. I think that's where our focus ought to be. So very much appreciate it. Appreciate that the District Attorney's Office and the Public Defender's Office work together in this, and we'll look to folks up here for additional comments. First to my colleague. Do you want to go after? Okay. Matt Fisk, Reentry Services.
I'm sorry.
Your light is on. Okay, Damon Silver.
Thank you. I just want to briefly say that these are the moments that make me really make me very proud being in government. These are the faces and the families and the people behind all the work we do as employees of government agencies. And I was able to come early today and get a chance to personally welcome Mr. Campbell and Mr. Fosselman home. And I want to acknowledge that they're really, in many ways, the driver of this work and the success. I want to thank them for taking the opportunity and making the most of it, also while playing it forward and serving the other men who are returning to our community. It's the commitment that they are making, and I think the collective commitment of our county that really is the foundation of beginning the healing of the community. Because at the end of the day, we are, and this work is at the root of, from my opinion, the race equity action and race equity healing, and looking at the past, the mass incarceration history, and us beginning to deal with it. And these reforms are what are addressing it, and it's really the collective commitment of the people in this room, the partnerships between the agencies in this county, and really the leadership that has allowed us to do it in a very different way. So I just want to acknowledge that none of this would happen unless it was people like Mr. Fosselman and Mr. Campbell making the most of this opportunity, but also the collective leadership in this room.
Thank you. Sheriff Johnson.
We're going to pass the mic. I appreciate that, TM. Really just wanted to take a moment, and I've said it before, but not only thank the Public Defender's Office and the District Attorney's Office, but this program was very, very instrumental. And gentlemen like Mr. Fosselman and Mr. Campbell, I think it was in 2020 when you did a webinar on a couple of recent releases, and it was hearing their stories that really made it critically important for us at the Sheriff's Office to make this an operational priority of having programs accessible to people as soon as they come into incarceration. Because that's one of the things I had heard from a couple of these individuals at the state level, that even though they were in the state level, it sometimes took years before they would get accepted to the programs. And to, I believe it was Mr. Fosselman's comment, get off their butt and start working towards the betterment of themselves. And that's something I just think every person should have the ability to do. So I really want to thank you for sharing your stories. Thank you for your leadership. It's a great movement forward for this county of Santa Clara. Thank you.
Thank you. District Attorney Rosen.
Thank you very much, Supervisor Ellenberg. I just wanted to say it's a pleasure to see in person Mr. Fosso and Mr. Campbell. We have a sentencing review unit in the DA's office that works with the public defender's office and the court, and all of these early releases and resentencings are things that I personally sign off on, every single one, because if someone gets out and doesn't do as well as the two of you are doing and then reoffends, that jeopardizes the ability of others to get out early when they should. So I really want to commend both of you on how well you're doing and how you're helping others who are getting out to do well as well. So thank you very much, and it's really just a pleasure to get to see the two of you in person, having read about you previously, but it's nice to meet you in person. Thank you.
Thank you. Independent Public Defender Perez.
Just congratulations to the Public Defender's Office for such outstanding work and for giving us really the inspiration to continue to move forward. These presentations are what matter to remind us about how much work we have ahead, but yet how impactful it can be every single day. And a lot of times when we're in the middle of such an overwhelming task that seems like a big mountain that we cannot climb, it's stories like these that maintain kind of our spirit to move forward and to fight. So I really want to thank you for putting this together so that we can continue to be inspired to move forward. And I also want to acknowledge Jeff Rosen and the DA's office for their support and collaboration. I know that it's not easy to take on these challenges. There's so many dimensions to getting the releases signed off. But I do want to say that one of the most critical components that we've seen to be the success is when we give judges and DAs the peace of mind that the clients that we're seeking to be released are going to have the resources, like somebody who's going to pick them up, like a place for them to live, like somebody who's going to guide them, like that mentor. And those are expensive resources, but they're necessary resources, not just for the peace of mind that I'm talking about that's going to make the release possible and legally feasible, but as we mentioned and as we heard here today, they're absolutely indispensable to ensure the success of the citizens. They have the well-meaning and the great intentions, but also the tremendous fear and horror of what's going to be like in the community if they don't have the foundation to succeed. So thank you very much for the presentation.
Thank you so much. It truly is baffling that the state has failed to provide dedicated resources to this work, and I would continue to flag this as an area of focus for our own IGR team, and I'll make a quick comment about local funding and then go to you, Supervisor Chavez. The post-conviction work really, as well as the PAR and the mental health pre-arraignment review and representation pilot that we'll be discussing in the next item, in my view, absolutely have to be prioritized in the budget. I do have concerns with positions that support this work being proposed for deletion. I'll save those comments for the upcoming budget workshops, but we are laying a foundation here that makes such a strong, incredible case for investment that it would really be undermining our own values, statements, and commitments to not fund to the extent that we can and to continue to pressure the state to do their part. Greta looks like she's going for her.
Yeah, I was just going to add one comment on that, which is just one of the things that we've been talking about with our, can you all hear me? Better, yeah. One of the things that we've been talking about in our department head meetings, specifically on the point you just made, Supervisor Ellenberg, is when we have new state legislation that creates really wonderful opportunities that we very much support and want to invest in, but also significant additional pressure on the resources we have locally, making sure we're immediately getting notice out. And I know the public defender has been in touch with the county counsel's office after that discussion in our department head meeting about trying to quickly identify where we see legislation like this that creates wonderful opportunities, like the ones we heard about today, to quickly do some analysis to see, in addition to seeking legislative support to actually directly fund these things, also being poised to file unfunded mandate claims against the state to make sure we're leveraging every opportunity to grow the set of resources we have to do this wonderful work. And we have, in this presentation, I was thinking the savings to the state of not having to pay for state prison time for many of these folks is immense, and is certainly, I think, larger than the amount they would need to spend to support the incredible work that we heard about today. And so I think there's really an opportunity for us to lead statewide in trying to shift state investment in these sorts of programs with the level of support folks need, based on some of the amazing work. And thank you both to the Public Defender's Office, the District Attorney's Office, and it was beautiful to hear both of your stories. So thank you for being here with us today.
Supervisor Chavez.
Yes, thank you. First, I just wanted to say to both Mr. Campbell and Mr. Fosselman a very sincere thank you for being here today. I think, you know, publicly telling your story is not easy, and especially in such a weird environment. And I have to say, I've been in public office a really long time, and I still get nervous when I speak at the rostrum over there. So really, really do appreciate you being here. The one request I want to make is that I think so I would just say to all of us that when we're giving presentations about projects like this, that having the folks who are coming forward be part of our panel is just a preferred thing than 2 minutes. And the other thing I would say is that as much as possible, if we could narrow the presentation, because I actually have some questions I want to ask, but we don't have time for that, so that we can have a deeper discussion about what the implications of what we're hearing would lead us to. And then the other thing I just want to ask, I really wanted to ask this of Javier, which is, I think it would be of incredible value to have a conversation with both of these gentlemen about the work we're doing at reentry, because one thing, again, if we had time, I would want to better understand is the linkages of all of these programs, but to better understand and how the receiving at the reentry center matches and marries what I apologize, I'm not sure which speaker mentioned this, but said, you know, look, if I'd had this, you know, the first or second time I was incarcerated, this could have had a different outcome. So I would just request that if you could spend some time with them, with some of the staff at the reentry center, just to better digest their experiences so that we can improve our services.
Absolutely, and I was going to invite both gentlemen to our upcoming Lived Experience Advisory Board.
Excellent.
They could share their stories and how we could improve our reentry system. So thank you.
Thank you, thank you.
Thank you very much. Do you want to make that a motion with your direction?
So moved.
And a second, and we have heard from the public, and I don't see any further lights on, so let's vote on this item, please.
Vice Chairperson Chavez?
Yes.
And Chairperson Ellenberg?
Yes.
Thank you. Motion carries.
Thank you so much. And thank you again to our presenters this morning, and really hope that you both continue to do so well. Item 6 is a report from the Public Defender and District Attorney relating to the Mental Health Pre-Arraignment Review and Representation Arraignment Calendar Pilot Program. Megan, welcome. Who would like to introduce this item?
I was going to say,
turn the mic on.
Ms. Piano. Megan Piano is our supervisor of our PAR unit, our pre-arraignment and review team, but I think everyone is familiar with her. I'll hand it off and ask her to briefly introduce herself and begin the presentation.
Good morning. My name's Megan Piano. I'm the supervising attorney of the PAR team at the Public Defender's Office, the pre-arraignment representation and review team. I am always thankful for an opportunity to sit here and talk with all of you about the services that the PAR team is able to provide. Just to recenter us, our office and our county are leading the state and the nation in this new area of public defender representation. Traditionally, and in most courtrooms across the country, a client or a defendant does not meet their attorney until they are sitting in an arraignment calendar with 20 to 30 other individuals who are also meeting their public defender for the first time. But in our county, we are challenging that paradigm, and we are meeting individuals within 24 hours of booking in the jail to get to know them, ask them, how are you? Are you on your medication? Is there investigation we can do quickly? You know, do you need us to call your mom? Don't worry, you're not gonna get deported. We are now, in some sense, providing a completely different level of representation. And I know I've talked to you all about it before, but I just think that the ability to do this work every day continues to make me love being a public defender in this office and in this county. Over the past 16 years of my career, before I was involved with PAR, I have always had a sort of specialty within the Public Defender's Office of working with individuals who are struggling with mental health issues. So I'm very excited that I get to sort of marry my two passions today and talk to you about our mental health PAR arraignment court pilot program. The title, Safety and Wellness, has been asked to be changed by many people. So our mental health PAR pilot program is going full speed ahead, and we are so excited because many of our system partners that are sitting up here today are supporting this, engaging with us, and really helping make this dream a reality. The Mental Health PAR Arraignment Court hopes to provide at the outset of a case early intervention for our most vulnerable clients. And early intervention to me means speaking with them within 24 hours of an arrest to see their level of stability, whether they're on their medication, whether they're suffering from some kind of psychosis. I mean, the spectrum of what could be happening with any individual is huge. But also, in addition, and what we can't always do now, and we'll talk about this in a minute, is reaching out to behavioral health, reaching out to custody health, reaching out to their previously assigned attorney. Perhaps that's somebody who's in the mental health treatment court, and we'll talk about again how that's different than what this is, and finding out what's going on right now with this person. What services are not in place that we can provide to help stabilize this individual and get them back into the community in a way that not only supports them, but also protects public safety. In February, many of you that are up here were also part of the joint City of San Jose and County of Santa Clara presentation that did have a lot of discussion of high utilizers. I'm not going to go into the statistics and all the definitions and all of that today for this presentation. I just wanted to note this one slide because I think it's incredibly important to support the reasoning behind why I am so passionate about this new calendar. The Public Defender's Office identified high utilizers based on our own definition, which was 15 or more criminal dockets within the last 3 years. So 15 or more criminal dockets within the last 3 years. We would then, if you qualified under that, you'd be considered a high utilizer by our definition. We were able to identify 70 people in February of 2024 who, within the last 3 years, had had 15 or more criminal dockets. Of those 70 people, 82.8% had a mental health diagnosis. That's 59.96 individuals. That is huge. The correlation cannot be ignored. And anecdotally, we at the Public Defender's Office know that. We've seen that over the years because we are getting intimately familiar with those that we represent and learning about their struggles. But the data also is so compelling. We've had, like I said, many system partners who are seated up here today that have actively been engaging with us to make this pilot program a reality. The District Attorney's Office, my counterpart Brandon Cabrera, has been integral in helping drive this forward. Also, the Santa Clara County Superior Court has really made space for us to try this program out in a way that will not cost anybody extra, which I think right now when we're talking about budget cuts and everything, that is a crucial piece of discussion for us about this pilot program. One question that I received, I believe from Supervisor Ellenberg when we briefly discussed this idea many months back was, what specifically will be done differently and by whom if we implement this pilot program? And then also, what markers of success can we look to assess the actual impact down the line? Today, I'd really like to talk about what will be done differently and by whom, because I think that question is really important to understand. I'm not going to read through each of these steps in a criminal case up here because I know that you all have access to this slide and I know we're short on time. But anecdotally, we believe that a felony case where a person is incarcerated and also has a mental health issue takes on average 6 to 9 months to reach settlement. A case has to reach settlement before it goes to our current mental health treatment court. So 6 to 9 months to make that initial mental health treatment court appearance where you're assessed and then you're waiting for a bed to be released to receive your services. This calendar that I am proposing to you in this pilot program is a pre-plea model. So we are providing, or we are seeking to provide, assessment and stabilization at the very beginning of the process. Similarly, we have seen great progress in the field of mental health diversion. On average, we believe it takes 5 to 6 months of an individual who's held in custody with a mental health diagnosis to receive a grant of mental health diversion. Again, this is a grant is similar to a case resolution in that here you are earning your dismissal at the end by participating in all of the programs that are set up for you. But regardless, each of these results in considerable amounts of time in custody for those who are suffering from mental health issues. Our program will be pre-plea. Our program will identify individuals within the first 48 hours of booking. And the way that we aim to identify individuals are through various system partners. One, mainly through the public defender PAR team, who is conducting those post-arrest interviews within 24 hours of booking. Second, a superior court judge can refer individuals that they believe would be helped by this program. Behavioral health and behavioral health liaisons to law enforcement and law enforcement agencies may refer an individual that they think would be appropriate. And finally, individuals who have previous system involvement and diagnosis can be referred by any system partners. So for example, if we know an individual has 6 cases in front of Judge Manley, maybe they pick up a new case, but they had been doing really well but for this new case, we might try to streamline the resolution of this current case and get them back to Judge Manley, and so they don't lose their spot in their program, they don't lose their housing, they don't have to reapply for their medication. And so any one of the agencies who sit up here before me could potentially refer individuals to this program if it were to become a bigger program. Initially, in our pilot program, it will be small because we need to use the resources that we have and we need to be able to track the impact. Once we identify a participant and they are referred, they will receive an early mental health assessment from behavioral health, who has committed to conduct in-person and virtual assessments in the jail. We've received cooperation from the sheriff's office in terms of giving us space, and a public defender attorney will fill out an intake form and give a direct referral to behavioral health. This assessment will then be used within that week that the person is taken into custody and appearing for arraignment. That way, we will have up-to-date, accurate information about their current mental health status, services they had been receiving, and where we think it'd be best for them to go to remain stable and to protect public safety. The Santa Clara County Superior Court for this pilot program has given us Department 25 on Friday afternoons at 1:30, and we have all agreed that we think 10 dockets per week would be enough to make an impact and track, but also not so many that it would overwhelm existing resources, because no agency, I believe, at this point is receiving additional funding to participate in this pilot program. But by the time this individual arrives in Department 25 on Friday afternoon, they will have met with a lawyer who has spent time answering their questions, talking with family members, explaining their legal rights and options. They will have a behavioral health assessment that's up to date. They will have a plan for possible early resolution of their case that's been worked out with the public defender and the district attorney, and a plan for medical stabilization and release back into the community in collaboration with pretrial services, behavioral health, and the Santa Clara County Resource Reentry Center. These individuals will ensure a stable release, all of this with the goal in mind that we reduce the days of incarceration for our most vulnerable members of our community. Our anticipated start date is August 16th of 2024, and we are so excited to dig in and begin this work, and excited to report back to you one day what I know will be a successful pilot program. So thank you.
Thank you very much. I know that our time is so short, but this work is all so interesting. I want to share so briefly that during Wednesday's Behavioral Health Heroes Awards ceremony, everyone assembled had the opportunity to hear from a woman who shared how care coordination through Judge Silva and the collaborative court system partners had helped her make just immense strides in her path towards recovery after years of suffering from drug addiction and domestic and sexual abuse, impact of multiple undiagnosed and untreated mental health conditions, stints at Elmwood, losing custody of her children. And when she stood and spoke yesterday, she talked about having maintained her sobriety, regained custody of her children, and really is now an active pillar in the recovery community, supporting other women through her experience in the collaborative courts. And just as the gentleman that spoke earlier today, it is these individual stories that magnified show us exactly the impact of what we were doing. And her mom was there with her, and it was just a whole beautiful thing. So no big surprise that I'm very excited about this new pilot that's launching in the fall in Judge Paul's court. And I would request that we get a progress report next February or March, please, once that's had some time to marinate and be impacted. I can go to the public first. Do we have public speakers on this item?
There is one request to speak on Zoom.
All right, no one in chambers. We will hear our single speaker on Zoom, please.
Our next speaker is Ben. Ben, I'm unmuting you. Please accept the unmute. You have 2 minutes to speak.
Yes. I think it is important to magnify the success stories with this pilot program. But we also need to magnify potential abuses using this pilot program, because I can tell you that the use of mental health court can be used in bad ways as well. And I know that it might be difficult for some people to comprehend this, but people can send matters to mental health court when they want to discredit someone. And the reasons that people cite to send a person to mental health court are the exact accusations that a person is making. For instance, if you tell somebody that your kids are being sexually abused and you've told the district attorney personally in 2017 that your kids are being sexually abused, then that is a reason to raise a doubt and send the matter to mental health court. He's crazy. He told the district attorney in 2017 that his kids are being sexually abused. he's also telling people that he's being assaulted. That's another reason. Let's send it to mental health. And I'm telling people ahead of time that my former attorney, Valerie Houghton, wants the matter sent to mental health court, that she's going to tamper with anything. And when I refused to use or to undergo an evaluation, a psychologist paid by the taxpayer made a determination that because I accused this attorney of sex trafficking my kids, that I am mentally incompetent to stand trial.
Thank you. My motion is to receive the report with a direction for a progress update next February or March.
Second.
Thank you. Any comments on the dais? Seeing none, let's vote, please, Nancy.
Vice Chairperson Chavez
Yes.
and Chairperson Ellenberg?
Yes.
Thank you. The motion carries.
Thank you very much. Item 7 is something very valuable, an update on monitoring services and client impacts and reentry. Pretrial Services Matt Fisk has graciously agreed to go right to questions. We have the report in our files, so thank you for that. I really appreciate the thoughtful report. There are just 2 areas where I'd like to get some additional clarification. First, can you provide some context on how the department determined the optimal client to officer ratio of 75 EMP clients and 100 SORP clients, and what is our current ratio?
Certainly, President Ellenberg. It's mostly anecdotal. Most pretrial practitioners would say 50 EMP clients and 75 supervised OR cases is feasible. We think that because we have support like you don't see elsewhere, and with some technology improvements, we think we can handle more. And so, when we get there, we'll make adjustments, but that's the goal that we're shooting for, we think is reasonable.
Okay, so anecdotal, there's not a formalized best
No.
practice or recommendation.
All the jurisdictions kind of do it differently, so it's hard to lock it into a specific number.
Okay. The second point I'm hoping that you can detail a little bit further is the process for stepping down a client from EMP to SORP. I appreciated the department's reflection on the potential negative impacts of overextended use of the electronic monitoring, and was intrigued by the data that indicates that both programs have nearly equal performance outcomes, which of course begs the question of, do we need as much EMP, and I think that's partly a question for the courts making that decision. So just kind of thinking if it's not putting you too much on the spot, Judge Giffon, but just a little. If you're seeing data that shows that outcomes are the same, people are coming to court with or without the EMP, would that, do you think that's something that would influence the judges, or do you think there's a risk that if we use the EMPs less, that fewer people will be released at all?
I think it's an ongoing conversation that we've had. Matt and I have talked about this many times. I do think having data is helpful. I think judges oftentimes are asking for, in my experience, as much information as possible about the outcomes for people that are placed in various types of release. I do think that it can help judges make better decisions to have more data about the outcomes, and I think ultimately may result in fewer people being placed on electronic monitoring or being stepped down, as Office of Pretrial Services often requests after a certain period of time. So the more data about that, I think, would be more very beneficial to the judges making these decisions.
Thank you so much. And why is it, is this also anecdotal, that it's about 6 months when the step down is evaluated? Why not more? Why not less?
It hasn't actually been 6 months. It's been kind of driven by the defendant's compliance and stability and timing for the court. It's very labor intensive for all the justice partners to have a court hearing, and those court hearings compete with other court hearings, right? And so Pretrial Services is working to provide more robust information, contacting victims, really a lot better information for the defense, prosecution, and court to make an informed decision a lot earlier on. That's the key.
Coming back again to why the data is so important, because if people have them on longer, simply because of the difficulty in securing a date in court, that seems less compelling, certainly, than a safety requirement, but I understand that it's a reality. So thank you. I appreciate both of your thoughts. Sylvia?
Well, I just want to stress that, yes, the information to the judges is important, but just as equally important is to the DAs, right? When we're arguing release and the DA is concerned about community safety, and the perception is that EMP is going to be a greater assurance thereof, when in reality, the data says, that they're equally as effective. That's just as important, as well as talk about incorporating the step down as an automatic consideration if there's no new violations. So for example, not have to come to court if there are no violations after the first 30 days, for example, and that's a stipulation and an agreement so that they don't have to come to court. But I think it's the information that we need for the defense and the DA and the court is very, very important, because there are sort of perceptions that are just not necessarily accurate.
May I?
Yes, please.
Thank you. Thank you for the report. And you are always so detail-oriented that I always learned something that I thought I knew and I didn't. I have two areas that I want to just dive into. One, I think we'll maybe talk more about as part of the county budget, but I am concerned about your ability to have full-time permanent staff on your team and not rely quite so much on extra help or on kind of putting pieces together. And the reason is that if this becomes a very solid part of our system, we need to really grow the leadership, grow the skill set and all of that with this group of folks, again, so that the community and the courts and the district attorney and all of our partners can have confidence in it. So I'm more saying to our senior staff here that when we get to budget, I want to understand under what terms and conditions different departments have extra help versus permanent staffing. That's one issue. The second issue is, and this actually, I'm so grateful to talk a little bit about what we're learning in terms of behavior and when something works, what tools work and what tools don't work. And one thing that I would be interested in understanding is also what kinds of activities does somebody who is on EMP versus SORP, what got them into our criminal legal justice system in the first place? And the reason I'm asking this question is that knowing what tool works, I think, may also have to do a little bit with the kind of crime they're accused of committing. And the one thing I want to make sure that we are mindful of is that as we're looking at data, that we really are understanding the criminogenic behaviors that get somebody into our systems in the first place. Because when you're looking at somebody who may be committing acts of domestic violence or stalking or other kinds of issues like that, we also have to think not only about that person and how we help them get on the right path, but we have to be thinking very carefully about that victim and the victims as well in terms of how that person is being re-engaged in the community. So as we further dive in, I would just be interested in what we learn relative to how and why somebody is given SORP versus EMP, and then when that changes. Because what I don't think, I think you raised a really good point about automatic changes. I would say yes, depending on the crime that they're accused of committing, that has to be a big consideration as well. Thank you.
Thank you. Did I take public speakers on this item? I did. Good for me. Do we have a motion?
I move to receive the report and just to ask staff during budget if we can cull out this particular body of works to better understand the employment, the status of employees. Thank you.
Thank you very much. Looking for other lights or comments. Seeing none, let's vote on this item.
Vice Chairperson Chavez
Yes.
and Chairperson Ellenberg.
Yes. Thank you very much. Item 8 was held by request, so we're moving to item 9 right now, which is the Reentry Housing Capacity Report. And Javier Aguirre, Director of Reentry Services, has also agreed to allow us to go right to questions this morning. So I'm happy to do that, if that's all right with you. We can take public comments first. Do we have public speakers on this item?
There are no requests to speak.
All right, thank you very much. I will just want to thank you, Javier, and Key, and others for putting together the report. It really is helpful to see available housing resources. When it comes certainly to our system capacity and remaining need, though, there's still some information that I think is missing, and want to pose a few questions to staff, or requests and direction. First, I'd like to receive kind of some kind of visual, a diagram or a flow chart that shows the different pathways and places that an individual re-entering might be referred to for housing support. For example, someone might leave custody and not need any housing support. So a flow chart for them would have one line and no connection to services. Another individual who's identified while in custody as needing behavioral health supports and lacking stable housing might engage with many different levels of housing supports, whether it's crisis residential, supported shelter, permanent supportive housing, and would have sort of a more complicated flow chart with multiple reference points. I'm also interested in seeing models for how individuals might move up or down from higher acuity housing supports to lower levels of support. And what I'm looking for, the goal I'm hoping to achieve with this kind of visual mapping, is really to provide a clearer picture of the types of services our clients need, how long it might take for them to actually access those services, and any gaps that are identified as a result, so that our reentry clients can actually access the housing services that they need at the point they require them. Essentially the same thing we're saying about people with mental health needs. Can they get access to the bed at the acuity level when they need it? And when I see the narratives of different things that we have available, to me there's still a gap between what may exist and exactly how people access it. So I'm really just looking for a nod there.
Yes.
And then second, I'd like to see how you can track the wait times for how long for how long it takes for a person to access a particular housing support. That can help us understand bottlenecks and further potential areas of need. And again, I know we have far more resources than very, very many other counties our size, as well as bigger or smaller. But I need to be confident that we have the throughput also, that people are utilizing and understand how to access and do access our services.
Yes, we could definitely do that, and I think we could do that for like a specific number of individuals that are being case conferenced, so we know like when the individual asked for the housing, requested for housing, and then the connection. We see about quite hundreds of individuals seeking housing assistance, but it's all about who they're being case managed and navigated. So we could definitely do that for a specific targeted population. And then use that to kind of expand that to
Supervisor
others.
Chavez is saying she understands that.
No,
I'm
but I
still
got
looking
your
blank.
look on your face. I mean, I think if I could just.
And then I'll go to Greta.
Yeah,
Please.
if I could just weigh in, I think the point that you're raising is actually part of the reason this report is a little bit, it's so broad, which is that we have a lot of people helping a lot of people in access services in a lot of different ways. And the problem with that is that it is really difficult for us to understand what the wait times are, irrespective of the way the person engages with us if they are going through the reentry center. And so, Hillary, I just wanted to say thank you also for the report. And I want to reinforce that the questions that President Ellenberger are asking are really important to me too, because I don't know when we will be done with a particular type of housing, and I can't prioritize what that is based on the information that we are getting. And I know it's complex, but we're at a point now where in our systems where we have to take the complexity and frankly undo it. Because and then this is kind of a separate issue, but again, this is more of an issue for the leadership of the organization, that we have a lot of, as you all can see, different boards over the years have said, we want to understand why there's reason for the recommendation, whether or not we're helping seniors, what's the impact to children, what's our sustainability. These become the questions that we just box check. But the real question that I don't know if it goes on a form or not is access. Because we have all the programs in the world, but if we don't know who can access them and how hard it is to access, we don't actually know if we're providing the service, even if we say we are, right?
That I understand. Thank you. Greta.
I was going to just maybe make a related point, which is I think a challenge we sometimes face is we try to have a system that has no wrong doors. Right. And then sometimes when we get, what is the wait time? Well, it's like, at which door? Right. And so I think some of the complexity we experience is trying to give you a really precise answer to that question, and it can vary. And then sometimes we have folks who qualify for multiple programs and therefore can be prioritized in different ways. And so I just want to acknowledge Hillary, which I know Supervisor Chavez, you did, who is in part trying to work in close partnership with Key to answer those sorts of questions, as we have certain housing allocated for folks with behavioral health needs, certain housing allocated for folks with criminal justice needs, with other, prioritized because they have families with young children. How do we actually get our arms around all those systems as a whole? And that's a core part of the responsibilities that we've charged Hillary with. So more to come on that, but it's definitely a problem we agree with, and trying to reconcile the no wrong doorness that we want to maintain while also having really good system-wide visibility is complex, and we're trying to tackle that in really strategic ways, but it will take some time.
Thank you. And Hillary, happy for you to weigh in, since you're ultimately actually doing this work for us. But I just want to emphasize visual over narrative so that we can really see the flow. But happy if you have additional thoughts to hear those.
Nothing to add.
Okay.
But I like visuals too. So
no pressure. Okay, great.
We're good.
Thank you so much. Do we have comments from any of the folks up here? Seeing none, we have a motion, I believe, by Chavez. Did you make a motion?
So moved.
All right, and a second by me.
Vice Chairperson Chavez?
Yes.
And Chairperson Ellenberg?
Yes.
Thank you. Motion carries.
Thank you so much. Thank you to everybody today. Item 13 is announcements. I will look up and down both rows to see if any department heads have announcements today. And seeing no lights, we will, seeing a light. Go ahead, Chief Probation Officer Burchard.
Thank you. Just wanted to highlight and thank Javier's folks and Matt's folks at pretrial that we had a resource fair at the adult building a couple weeks ago, and we had 30 vendors and over 250 clients who signed in to receive services. So it was a very successful program. Just appreciate everybody's support and help on that. And then one other thing I would just like to highlight is our Secure Track youth, SB 823, and our youth that are here locally. We have a youth who recently has graduated from junior college and who has been accepted into Berkeley.
Woo, go Bears.
Yeah, which is just incredible for this young person who's been with us for quite a while.
Wow.
We have a number of youth who are enrolled in college in our Secure Track, a number of youth who are taking classes, and we've had 4 or 5 who are in the process of reaching out to colleges to get accepted. We have some in Riverside, we have some in San Diego State, so just some incredible work being done.
Thank you for sharing that. Seeing nothing else, we will adjourn to Friday, May 3rd, 2024 at 10 a.m. Right here in Chambers. Oh, that was a wimpy.